Well, good afternoon. My name is James Vann. I'm an attorney here with Vann Attorneys. We are so delighted that you have had a chance to participate today, that you are participating with us in this webinar. We're going to be talking about the realities of debt collection, primarily commercial debt collection. What you as a business owner or credit manager, CFO need to be thinking about, right? What you should know. Before we get into that, a little bit of homework that we have normal, right? If you have a question, you can use the GoToWebinar control panel on your screen, send it to us that way, or you can email it to us at Vann Attorneys webinar at vannattorneys.com. Sorry, I hadn't given that out in a while. So again, if you have a question, we'd love to hear from you. And we want to say thank you so much to so many of you who give us topics to talk about. We're always wanting to make sure that we are hopefully hitting the itch that's scratching, or the scratching that's itching. All right. So if you have a topic that you really want to make sure that we cover, please send us a text, email, whatever, phone call. Let us know. We're going to be doing a webinar on August 12th, which is a Wednesday, is our next one, 3 o'clock, and we're going to be talking about AI. Honestly, we were just talking about this before we went live today, and we're trying to figure out how to make sure that this is beneficial to you as a business owner or a business professional. We've got some really good topics, I think, having to do with AI. So we hope you will sign up for that. You'll start getting some information about that in a couple of weeks. I also want to say a really special, big thank you to Michael Fernald, who works with our office. He helps us with IT and some other just business stuff with our office. Michael's been here for a number of years. Michael, I really appreciate your help. He helps us get all these webinars together. Helps us get it online and make it available. So thank you to you, Michael. Really appreciate you and your insight. So about today, right, we're going to be looking at information about what the legal process is, timelines, the financial considerations, all kinds of stuff, right? And it's really hopeful. The idea is that we will be helpful to you and hopefully hit topics that are important to you as we talk about dealing with debt collections, right? Unpaid accounts, right? Obviously, we talked about this a lot, disrupt your cash flow. And obviously, it can impact your long term growth, right? I know a lot of companies that they're carrying hundreds of thousands in receivables in a 90-day category, right? And it just grows depending upon how big your company is, and also depending upon what your terms are, right? Some of those numbers can be sort of detrimental to how you grow, right? We want to make sure that we are helping y'all with that. And then hopefully, again, if you've got questions, let us know. So why does this matter to you and to your bottom line, right? We all know every receivable that goes into a aging like 60 to 90 days, right, can impact your company pretty significantly. You need to be looking at how to hopefully speed up the process of your customer paying you. I know a lot of y'all are doing that, right? But the longer an account sits, we all know, right, the harder and more expensive it becomes to recover. Statistically, and I've been doing this for 30 some years, and many of y'all have, I know as well. The stats have not really changed much. As accounts get older, they say that the difficulty of collecting them go up. I can tell you a lot of times it has to do with whether or not the customer is still in business, right? At the same time, whether or not the people that you're dealing with are still there. Um, time the time that erodes by, right, erodes the value of your receivable. The probability of recovery declines as it gets older. So we obviously want to hit it quickly, as quick as we can. People, will call us, clients call us all the time and go, "Hey, look, when should we hire y'all, right? Versus doing it yourself." I typically tell our clients, if your terms are 30 days, right? At 60 days, if they haven't paid, you need to hopefully have a phone call with your customer 75 days, you need to know what's going on. And again, if you have lien rights having to do with construction or improvements to real property, then by 90 days, you really do need to know, hey, what's going on? Where's the money flow with your customer? What's the issue with them? Because you've got 120 days to deal with a claim of lien. Outside of construction, I would tell you 60 days, 65, 70, 90, heading into 90 days, you need to be hopefully have had multiple conversations with your customer, know what's happening, but at the same time, I would say by that point, start thinking about turning it over. So hopefully that makes sense. We've talked about that cash flow obviously drives growth. Unpaid accounts type your working capital. It's actually a cost because you have to borrow money for operating capital. It's going to cost you just to keep operating and keeping the doors open. Obviously, having a process will help you and your company long term, right? At this point, we do this, and at this point, we do this, and at this point, we call the attorney or send it to the attorney. But again, having that process hopefully helps you to say, hey, look, this is just our company policy, right? When we get 60 days, it goes from this person dealing with it to this person, or however you want to design your collection process. I have found over the years it's very beneficial to explain to some customers, not all. Sometimes they think they're dealing with a customer and they go, well, or with the creditor, they said that, well, the creditor, they have so much more money. They don't really need mine, right? It's not that big of a deal. And when I explain to the debtor, your customer, about, look, they have an operating cost just like you do. And when they don't get paid, they have to borrow money, number one, to keep for, operating purposes. Or at the same time, if they're not borrowing money, it's still costing them because they're having to pay people to make the phone calls to collect the money, right? And then when they start thinking about that, it's really amazing, right? Sometimes you can hear and see the light go on, and they go, "Oh, okay, I get that now." Or at some point, you just say, "Hey, look, because this is now in the 60 to 90 day category, or 90 to 120 days, whatever it may be." This is now gone from dealing with the credit manager, the CFO, or the controller to the next level, whatever that is, and just say, this is not a personal decision, it's business. Their CPA or their attorney is saying to them, y'all have got to get this thing taken care of. And a lot of times when we've explained that to one of your customers or to the debtor, again, they sort of think, they start, oh, okay, I can do that, right? I'll get that taken care of. So again, just to give you a little bit of background on it. So we're going to be talking about what to prepare, what documents do you need to do, what's the collection process, and then from filing it to getting a judgment, how does that work? What does it look like? What's the cost and fee structure with attorneys? How do you typically handle that? Debtor defenses, and then improving your process. So as we get ready to start on this, right, what do you need to do before turning over a claim to us or another attorney's office, right? Well, get your documents together. That's generally speaking, because we do a lot of the commercial side of it. That's one of the first questions we ask, right? Hey, look, send us a copy of the contract. Is there a credit application? Is it a purchase order? Is it subcontractor agreement? Whatever it may be, right? Send us a copy of the contract and any agreements. If there are any modifications to the contract, you want to see those. If there were changes either by email or text, let us see those, right? Also, look at the account summary. Get an idea of how much is owed, how old it is, have they made payments, and when were the payments applied. Also, you want to look at the customer details, right? Are they incorporated? What kind of a business is it? Is it an LLC? Are they current with the Secretary of State? Are there any personal guarantees? We've opened a number of cases in the last 2 weeks for some clients. Then thankfully they all have personal guarantees. We have talked about that, several times in our webinars. And if you ever have a question about that, let us know. But we certainly would encourage you to have personal guarantees if you can in your line of business, because it really does help get the attention of the customer when they realize that they've got a personal guarantee. I had one I think it was last week, two guarantors. I happened to know one of them, so I just socially, so I picked up the phone and I called him and said, "Hey, this is coming. Make sure y'all understand it." Of course, he had no idea that the account had gotten past due. The other guarantor is running the company, and we got word that the next day, before they even got the demand letter, that they had paid the account, which was great for our client. So that's, great news. But again, having the guarantor is a really big deal. Again, and knowing what entity and where they're incorporated, right? Sometimes we get stuff, and it's obviously um, pretty clear that when the customer set the account up, that they didn't really look to see if they're incorporated or not. Just because you have ink behind your name doesn't mean you're incorporated. But again, knowing what entity and what the customer detail is really important. Also, we said look at the purchase orders, look at any kind of delivery confirmations, and also just correspondence or communication. I talked to someone last Friday. I think we're going to be able to help them. They sent us text messaging back and forth between them and their customer, which I think is going to be a huge help in getting them paid, thankfully. So again, however that communication is, if it's important, send it to us so we can take a look at it, right? So just a little quick self audit before you turn an account over. The more boxes you can check, obviously, hopefully the process gets smoother for you. Do you have a signed contract, credit application, terms of sale, personal guarantees, corporate guarantees? Do you have copies of checks, right, or how they paid? Proof of delivery, that kind of stuff, right? It's with technology now, it's so much easier to get that than it used to be. So again, that gives you a little bit of an idea of what documents to put forth and to be prepared. And again, and you can send that by email to us or whomever you're dealing with, because that's a lot easier today. And then once you place it with us or with another firm, mostly for the most part, it follows a pretty straightforward path. As eventually it will start to change because every case has its own um, sort of its own temperament and personality. But at each stage is an opportunity, obviously, to get it resolved. I will say, and it's really interesting, right? And I know y'all feel this as well, whether or not how the money flows in from one business to another. It's amazing, right? That you get these customers who know they're getting the invoices, they're getting the emails of, hey, you're past due, they're getting the phone calls. And then when you send a demand letter or when we send a demand letter, they go, oh, I'll get it paid. I know we had a fairly large number the last 2 weeks that we've sent out, and I'm going to guess 30 or 40% of those got paid immediately, which is awesome for the client, right? And again, that's not always the case. We know that, but it was just really good to see those. I'm like, that's fantastic. So again, place the call the attorney, email the attorney, right? We look at it, evaluate the claim, try to make sure we understand all the issues around it. And sometimes there are obviously issues with what was delivered, how it was delivered, if there's damage, if there's delays. We were talking to an attorney today, and um, it's having to do with cabinetry, and a subcontractor was not responding to our client, and eventually said, "Hey, look, you got 48 hours to perform." Well, they didn't give them any head start to prepare for that ahead of time. They just said, "Hey, look, you got 48 hours to show up." That was unrealistic, right? So that's going to be interesting to see how we're going to get that resolved. But obviously, there could be issues like that in your case, right? We typically send a demand letter, and it's amazing how the world has changed in the last 10 years. We still use certified mail because the law tells us that's probably one of the better ways of doing it. There are other ways that sometimes you can send a demand letter. Unfortunately, email has not become an acceptable way of doing it. So we do a lot of certified mail every single day. So you get the demand letter out. we typically pick up the phone and try to call the customer at that point, your debtor, your customer, and say, hey, look, we've got a past due account and it's X number of dollars on behalf of, ABC company. How are you gonna get that thing taken care of? And try to get a conversation going. That's how we typically do it. And I feel like for the most part, it works out pretty well. Um, there could be times when there's negotiation back and forth. They say, look, I can't pay all of it now, but I can pay it over time. We obviously want that to be a short period of time and you get as much money as you can up front. And if you do that, then you obviously are in control of it, but we would say, hey, look, if you're willing to take payments, we need to have it in writing, right, with the customer. And I would say have something like a confession of judgment or something that gives you some negotiating power if they don't pay, right? It helps you because you've already had a promise to pay once or twice. Why would you take another one without making sure that you get paid? And then obviously if none of that works, right, or they don't respond at all and you're still out money, then filing suit and heading towards getting a judgment, right? Um, so obviously from the intake and review and looking at trying to get your head and hands wrapped around the general issues and what may be going on, send a demand, hopefully you get their attention. Sometimes you don't, right? Sometimes they just totally ignore it. You file suit or they just say, the heck with you, I'm not paying you because I'm not happy, whatever that is. And then we file suit because we, don't believe it. And then hopefully you get a judgment. Um, and then once you get the judgment, there's this process that we have to go through before we can send the sheriff out, right, to look for assets or to get to their bank account. That's typically what we do. I've been pretty amazed, right? I can get you might send us 3 or 4 cases. We send a demand letter out for all of them, and one might pay, one may say I'll do it over time. Another one says doesn't do anything, and another one says I disagree. I'm going to countersue you. All of those 4, right, take off in separate directions at that point. There's once you get a demand, you just don't know what's going to happen, right? You get a response, you got to figure it out. So hopefully that helps and gives you a little bit of guidelines. Once suit's filed, right, there's several factors that sort of go into play, right? Whether the debtor responds at all. If they don't respond once they've gotten served with the complaint, they have 30 days to respond in North Carolina. If they don't, we typically will get what's called an entry of default, where what that does is that stops them from being able to come to court later and then answer the lawsuit. There are mechanisms which the court would let them do that, but it stops it without them being able to come to court without getting permission from the court to file an answer or response. We typically, depending upon the dollar amount, we typically would set it up for summary judgment at that point. And the reason we do that is that it's a little bit harder for a debtor to set aside a summary judgment than it is a default judgment. Nothing wrong with default judgments at all, but they are easier to set aside. And the default judgment is just where they're defaulted because they didn't answer the lawsuit. That's just how we do it. I think it's the right way of doing it. But again, the law allows you to do both. If they do answer, then of course you got the court schedule and the docket with the court to figure out, okay, what do we do? We filed a lawsuit. They answered. We got to look at their answer and determine whether or not there's any valid defenses or if there's a counterclaim. And a counterclaim is where the customer sues you for something, or if there's a cross claim to another third party, not you, but they say no, it's not my problem, but it's XYZ's company's problem. And then you look at the disputes and defenses raised to see if there's anything in it that we have to substantively deal with. Sometimes it's valid, and sometimes it's just sort of legalese, right? That you go, yeah, there's nothing there, right? But it takes some time to go through that. And then from that point forward, you got to figure that out. So, okay, like I said, if they can splinter and go different directions, we try to figure out, okay, what do we do? Do we just go ahead and go for summary judgment rate? Do we try to push this through so that we get a judgment as quick as we can. And typically that's what we're trying to do, or more importantly, get you paid quickly. It could be mediation, that the court orders it to mediation. Mediation is a great way for business owners to learn and to listen to the other side and sort of get an idea of what they're doing, right? What they're thinking. And a lot of times I will tell you, I've said this to a lot of y'all over the years. Um, you might hear one thing if you're litigating it with your customer, but they don't want to pay for whatever reason. And when you get to mediation, you finally hear what you think is the real answer, right? They may be saying, "Well, y'all didn't do this right. You delayed the delivery of the materials, whatever, right? There's stuff made up, right?" And then you get there and that you find out that they don't have the money, right? Or they've lost a big customer, or they're struggling with something. But it's amazing what you hear in mediation if there's a good chance of it settling. And then, so let's talk about the cost and fee structures, right? And obviously this is not there's nothing new, but obviously you can do it on an hourly basis. You can do it on a contingency basis. And a contingency is based off of the fees that are tied to the percentage of what is actually collected. You can have a flat fee structure. I will tell you, there have been a lot of lawyers over the years that would love to get away from the hourly billing. I'm one of them. I'd love to, but quite frankly, sometimes that works out to our clients' benefit. Sometimes a contingency is better. We don't mind having that conversation if you want to, right? Court and out-of-pocket expenses. What does that look like? It depends again on the significance of the case, how big the case, if it's a full-blown, say, a business case, right? You may have to have some outside experts, or you may have to have someone else to come in. You've got deposition costs, you got to pay a court reporter, those kinds of things, right? You've got out-of-pocket expenses for filing fees with the court. Thankfully, they're not really large. If you're in arbitration, a lot of times people's contracts will have an arbitration provision. There are groups that have been around for a long time that help with arbitration, and they are enormously expensive. Their filing fees have skyrocketed. And that plays an important part. So there are other answers to that, a way of doing it. And I'm not using their name because I've got several cases with those groups right now that I just don't want to use their name that's going to be out on the internet because it'll probably come back to bite me. So I'm being careful not to say it. But they've been around a long time, but they're expensive. There are other ways if you wanted to arbitrate it that you could get a resolution. And then how do you recover fees and interest, right? I mean, we get this question a bunch, which is a legit question. The General Statutes of North Carolina says you can recover attorney's fees if the General Assembly has provided that recourse in the statutes. So it's got to be in the General Statutes to be able to get attorney's fees. So if there is a contract with attorney's fees provision in it, that's generally the best way of doing it. It could be that the case subject matter allows the court to award attorney's fees. And I will tell you, there are very few, there are some, but very few cases where you can get all of your attorney's fees that you've ever paid in that matter back. A lot of them are, at least from a contract standpoint, it's a percentage, the court's considered as 15% of the amount due and owing under the contract. So at least you recover some, right? You may not recover all. Sometimes you can get a windfall if the number is really big that you're owed and the attorney's fees is pretty small and you get a settlement, then, if you get your money early, you may recover more than that. So you just never know, right? Depends on what those numbers are. Interest, I really hope you've got interest provision. I know a lot of y'all on here do. You've got interest provisions in your contracts. So that's a fantastic thing. There's also a statute which we've helped a lot of y'all when you have asked us to modify your contract. You can get, say, for example, 18% not only until the judgment, but if you say a certain term in your contract, you can get 18% interest on the judgment until it's paid in full. Again, some people say, well, look, why would I care about getting 18% if I can't even get 6% or 5%, whatever? I get it, but I will tell you that gives you a lot of cushion. If, for example, you get a judgment, let's say it sits for 4 or 5 years because you can't find the assets, and all of a sudden they reach out to you and say, "Oh, by the way, remember that judgment you got against me? Could we settle that?" That interest provision gives you a lot of wiggle room if you want to use it for that reason to negotiate, right? You don't have to let it go, but you could or modify it. It just gives you a little bit of cushion. So I hope that makes sense. But again, that's just a great way of adding to what you hopefully can recover. So let's look at some common debtor defenses. Obviously, they can say, I didn't agree to that, or we hear this a lot. I didn't sign it. That's not my signature. Or they weren't authorized to sign. Then you have questions about how do you prove that. We've got a case right now that's probably well, actually, it's on the trial calendar for I think next month. And one of the guarantors said, I didn't sign that. I didn't have authority to sign that. And I wasn't a corporate officer. But it's really interesting. We've asked a number of people around them who dealt with them if this person held themselves out as an officer of the company. Yep, they sure did. We've got other documents that they signed as a corporate officer, um, doing very similar kind of things with other companies, with other vendors. And so, for them to say that I didn't have authority, or I didn't sign that, is really interesting. They're not going to be able to prove it, right? We've already proven, we already have the information to prove it otherwise. But that's going to go to court probably. And it'll be interesting to see what happens. Some other disputed goods or services, right? Claims that products were defective, incomplete, were not delivered, or damaged, right? Those are we see that sometimes. Billing inaccuracies, right? Or disputes. They challenge the amount that they were supposed to be billed. They said, hey, look, this product was supposed to be $5 per, but instead you bill me 15. Um, those kind of things, right? Timing limitations is something that we hear some, but not as often. Or if they go, well, hey, look, it's not us that owe it, it's another company or another group, right? It's not us. Or sometimes it's just, hey, I don't have the money, I can't pay it. So I will tell you, it was really interesting. We had a client a while back. I'm talking about the wrong party being named. There was this group suing our client, and they got the name totally wrong. And our client found out about it. I'm trying to remember how they found out about it. They weren't served with the papers, but they named the wrong party. And I'm like, why would we defend this? Because they haven't even sued the correct party. Well, they eventually got a judgment on a party that did not even exist. They just named somebody, right? I'm trying to remember how they got service or how they proposed they got service, but they didn't because it wasn't us. So we just let them go, right? And then they got a judgment that was useless because there is no entity named that. And then later on, they were trying to push it on our client, and like, hey, look, that's not us. And it was really interesting conversations later. The attorney was like, "Oh my gosh, sort of messed that up." Yep, you sure did. But thankfully, it was too late for them to come back. Um, so the other thing to think about is how do you improve your internal processes? I know a lot of y'all have great processes. You've got great protocols set up, but we can always get better. And with time, things change, right? Processes change. Some things that this haven't changed much, right? Get it in writing. We've got several clients that we talked about, and especially in construction, right? That with change orders, right? If someone says, "Hey, look, I need you to change this to this contract," go ahead and start now, but we'll get this later. Shoot a text, right? Thankfully, these things have gotten to be too easy to use, but they're also valuable. Shoot a text. Hey, you just told me you want me to do this, and that you're going to send a change order, and this is the price. Please confirm. And if they say yes, then you've got what you need. if they don't respond or they say no, I'd stop work, frankly. But that's just me, right? I think you need to figure that out, but think about what that is. But get it in writing with clear terms as you can possibly manage, and try to make sure that that other people are included in the conversation. A lot of times you want to vet the person that you're dealing with and do some research right up front. Make sure that they're who they say they are. Make sure that they are credit worthy, right? And they say true to their word. See if they've been in other litigation before. Those kind of things are what we would really encourage you to do. Make sure you are sending invoices, I would say early and often, right? And then follow up promptly to hopefully avoid any issues, right? If you don't hear anything, you don't get paid, then someone needs to be either picking up the phone or following up with the customer. Um, Make sure that your records are accurate and well organized. Thankfully, with technology now, it's a lot easier than it used to be. But you want to make sure that you keep your contracts, all of your documents, invoices in a place that you can easily find them. I am amazed with some companies that we deal with still that they haven't that process is not as cleaned up as you would think it would be, given the with technology the way it is. But sometimes there's a reason, a valid reason for that. But I would tell you, please keep it organized. Makes it easier for you. Um, Build a relationship with the attorney that you're dealing with. Who to call, when to call, and how, right? Before a crisis exists, before it blows up on you. I know a couple of y'all on here will call and say, I just talked to my customer, they've said this, what do you suggest we do? And sometimes it's just a follow-up phone call or follow-up from you as an owner or a uh, finance professional in the company that maybe says something different, right? And say, hey, look, let's do it this way. And sometimes it works. But you use the assets you have, right, to hopefully make work a little bit easier. So again, obviously speed helps and protects our value, right? Documentation is huge. And then know your economies, right? Those are sort of, again, hopefully some help, some things that may help. Um, Again, if you want us to help you, we ask you just to let us know. We'd be glad to do that. We try to turn it around the same day if we can. If we get it late in the day, then it may be it's obviously the next day. So let's let us know how we can help you. We'd be glad to do that. Again, we are really thankful that you have participated today. Hopefully, we will see you signed up on August 12th as we talk about AI. And we hope you all have an awesome afternoon. Thank you so much for dialing in.